matter of Parents for Educational and Religious Liberty in Schools versus Young. Counsel.
Thank you, Your Honor. May it please the Court, Avi Sheikh on behalf of appellants. And, Your Honor, can I please reserve 3 minutes for rebuttal?
Sure.
Thank you. The challenge
So
regulation...
why isn't the case moot?
Excuse me?
Why isn't this appeal moot, given the recent legislation?
Because the recent legislation does not speak to the issues that are on appeal to the challenge with respect to the enforcement authority that SED gave itself in the regulations. And in fact, Your Honor, there is enforcement that is going on currently, and when I say currently, I don't mean that in the broadest sense. I mean that since the enactment of this legislation, parents have received letters from local school authorities pursuant to the regulations and the directive.
Dated after the legislation?
Correct, Your Honor. Correct. So parents have received letters, and the letters say, and I quote, "Given that your child will no longer be able to attend," and then it names the school, "a decision must be made about which school your child will attend for the 2025-26 school year, and you must notify the Department of Education of where your child will be enrolled in school, and you need to do that
So let me ask you this. Given the new legislation, do you think that the local school authorities have the authority to send those?
Your Honor, we didn't think the local school authorities were acting within the appropriate authority to send them before the legislation.
But that's not my question, though, right?
So
look, as I read the legislation, correct me if I'm wrong, it gives you at least a 3-year window where nothing can be applied to you, at least.
So I think, Your Honor, it's a 2-year window, but let me step back and address what's going on here. So there are 2 groups of schools about which there's current enforcement. First is a group of schools where the State Education Department has already made a determination of non-equivalence, and therefore there's enforcement against the parents, and that enforcement, as I said, continues since the legislation. Second, there is a group of schools that had received an initial but not yet final determination of non-equivalence. And again, there is substantial communication and enforcement activity since the legislation has been enacted. And the question of whether the legislation speaks to those 2 schools, those 2 groups of schools, is one in which we've turned to SED to say, listen, if you agree that Part 30 regulations are withdrawn or null and void, we obviously don't have to be here today.
So it's SED's position that 130 is still a good regulation, still entirely enforceable? Was that the message you got from them?
The message certainly was that they weren't prepared to say to the contrary, yes, Your Honor. And that's the message that schools have gotten.
But isn't that a different record that has to be developed in light of the legislation? Not in the appeal before us?
I don't think so. Again, Your Honor, if one looks at, first of all, if one looks at the legislation, I don't think it at all lines up with the mootness cases that, that this court has
But
seen.
is it your position that SED can proceed with the enforcement actions that you're describing under the new legislation?
I guess, Your Honor, it's our position that as long as they're enforcing, all they have is a defense.
Well,
right?
I'm not sure that's responsive to the question. Are you arguing that it is permissible, or you think that it is not permissible and you would press that point?
Your Honor, we would press that point, but even if we prevail on that point, Your Honor, we would not, we don't think it's moot for the following reason. As Judge Wilson said, there's a pause in the legislation. It's actually, we believe, 2 years. But a 2-year pause on enforcement wouldn't make the case moot, not at all. If one looks at this court's decision in the Victoria P. versus Radcliffe case.
Well, but after, let me stop you for a second. After the 2 years, there's a whole different, the statute provides a whole different mechanism for determining whether you could be deemed to be in substantial compliance or not, right?
Well, it depends, Your Honor. It provides, let me step back. The way the regulations, the answer is it depends, but let me step back and explain why. The regulations, Your Honor, provide for a regular review.
I was trying to address the statute first.
Okay. Correct. So the legislation says that the legislation broadened the pathways that are available to satisfy substantial equivalence. It absolutely did that, Your Honor. But a school doesn't have to select a pathway, right? The pathway is a way to avoid a local school authority review. And what the statute did is it broadened the assessment pathway. But I don't think SED takes the position that, they can't do reviews if a school, in 2 years, if the school doesn't elect that pathway. And schools may decide the government assessment test or something else, they're not doing it.
I'm sorry, to elect which pathway? The new pathway?
The new pathway is an assessment pathway.
Oh, right, so the school may not, well, there's a new pathway that, you're calling an assessment pathway, which is basically students take a test year end, right?
Or a series of tests depending on the grade, and there's a series of subjects.
Yeah.
Yes, Your Honor.
Okay.
But
But your point is that schools might or might not choose that pathway.
correct. There's a series of pathways, there's accreditation.
Why is it not then sort of a ripeness problem on a case that hasn't been brought because the statute is new?
Well, you're not, Your Honor, because it's the same regulations. The regulations remain in place, and whether or not enforcement is delayed, I mean,
But
Your Honor.
the regulations may never apply to you.
Well, Your Honor, they give SED this right, and this is an Article 78, right? There's no other opportunity to challenge the regulations in an Article 78, right? It's a 120-day statute
Do
of
we know
limitations.
yet how SED will respond in terms of the regulations? I'm sure that they, can address this, but to the amendments, to the new legislation?
Again, Your Honor, it is our understanding that they take the position that that enforcement continues. And that's because, we've made inquiries and we see it in the field.
So, counsel, but this is a declaratory judgment action, right? And I realize that this isn't the question for you, but I find it very hard to see how the Reg 130 continues, since it basically describes one method of establishing substantial equivalence, how that could continue to be viable, given now that there are multiple statutory methods of establishing substantial equivalence. So what is there for us to declare?
So again, Your Honor, if the Part 130 regulations are withdrawn or declared null and void in some way, we are in perfect agreements. We're in consonance. On the other hand, if what they're saying is we're not sure about schools that were already declared not equivalent, and we're thinking through what we do about schools that had an initial but not a final determination, and we believe in 2 years we can enforce against the entire field, then it's an Article 78, and we get our decision, and it didn't, let's think of it this way, Your Honor, right? 2 years ago, the court didn't say, wouldn't have been appropriate for the court to say, that the case is not ripe because the enforcement is not here. In fact, if one looks at this court's decision in Stevens' case with the DNA registry and the familial, tracing through it, right? It was a concern that if the regulations couldn't be challenged now, several years from now, if a crime was committed by an individual, and if a family member's DNA was in the registry, they may get caught up in something in the
Can I
future.
But
ask
this
you-
may not even be the regs.
I'm sorry.
This may not be the reg in a month. This may not be the reg in a year, may not be the regs at the end of the pause.
Well, Your Honor, the fact that it might not be a reg in a year, that's always true. In any case, SED could withdraw its regulations, and frankly...
No, but
that's
here it's because you have an intervening legislation.
But, Your Honor, they
That
haven't...
obviously would supersede anything that contradicts,
But
in a
you-
regulation that contradicts the legislation.
But, Your Honor, they haven't done so, and this court...
Well, it just got passed.
It got passed a week ago, Your Honor, or it got passed by the legislature about a week ago, Your Honor, and honestly, in every case with an Article 78, in any case of regulations, right, the courts are clear that we cannot incentivize the agency to sort of delay the day of reckoning.
Can I ask on a different front, if we were to disagree and take the view that this was moot, what effect, if any, would the third department case have down the road, whether in 2 years or in 2032? Would it be appropriately vacated, or what would we do about that?
So again, if this court held that Part 130 is null and void...
That's not what I'm asking. I'm saying if we were to determine that the case presently before us is moot, what effect would the appellate division decision have, if any, going forward? Or would we appropriately consider vacature coupled with mootness?
Correct. So consistent with this court's precedent, right, the appellate division decision would be vacated and
I think there's a choice there. I think one can vacate when it's moot or not. And I'm asking, is there a reason that we would want to consider vacating it? And if so, what would that be? What would the effect be going forward?
Well, if it's vacated, then then obviously would not have any force and effect.
Yeah, but generally, we consider the question whether vacature is appropriate or not. And so I'm asking, what would the rationale for vacating it be?
It would be that it didn't get the merits determination from this court, and if allowed to stand, and it couldn't be challenged again, it would have a deleterious effect on the schools.
Could it not be challenged again? I guess that's part of what I'm getting at. So suppose that was the state of play, and down the road, whatever happens with the regulations happens. There's the additional pathway set forth in the statute, and there's some question that arises. In your view, would that be binding?
Well, one couldn't challenge. Well, one couldn't bring in Article 78 to challenge the regulation, as we've done here. So it would be
presumably a revised regulation. You could, but not this.
If there's a new regulation, Your Honor. But again, we're not there yet.
But you do have the pause. So isn't that just a completely game-changing development in the case?
Absolutely not, Your Honor. And the cases are clear that whether the consequence of the regulation will come in 6 months or in 24 months or 36 months, that's not a reason to not give a merits decision on Article 78. That's the Stevens decision. There's a number of decisions like that, because otherwise, agencies can do this all the time. That's absolutely 2 years is not a reason to say that there's no case of controversy. Not at all, Your Honor.
Fair
Can
enough.
I ask you? Go ahead.
Just one follow-up question, and I hear your argument on 130, and there are issues to be resolved there that might not have to do with you. But with respect to 3204, to the extent that you're seeking any relief there, clearly that has to be moot now, because it's an entirely different statute, right?
We've challenged the regulation in Part 130, Your Honor. We've never
Not
challenged
the statute.
Okay. Not the statute, correct. And if I can suggest, because my friend on the other side is going to get up here soon enough and may, declare that they're withdrawn or null and void or something like that, if I can turn to the merits.
Can I
because
ask
we
you
might know-
one
Yes.
question on
Yes,
the
Your Honor.
merits specifically? There's some disagreement, it seems to me, between you on the question of how and whether supplementation is allowed, and whether
Correct.
there's a single or multi-source requirement. Okay, so as a practical matter, if some supplementation was permitted, how would that actually work for a student at a school? If you have a school, and I understand you have objections to this as well, but if you have a school where SED determined it was not substantially equivalent, right? And so the student had to fulfill the obligation to attend upon instruction in some other way, would you be taking the homeschooling path? Would you do something else? How would it work?
Right. So what Supreme Court suggested was just like homeschooling has, an administrative process where the parent interacts.
Yes, but you would propose to follow that and follow those rules?
Certainly that's a possibility. I mean, the court also suggested it could be extracurricular activities, but whether or not it's homeschooling or something else, I think the notion that Judge Reiber was getting at was that, the parents certainly, can be obligated to communicate to the state how exactly it is satisfying substantial equivalence, whether it's through home instruction or through extracurricular classes or through some tutor or something.
And I don't
like
think
that.
you're contesting, but tell me if I'm wrong, that there can be a substantial equivalence requirement imposed. I take it you're arguing about how that might be implemented. Is that right?
Correct. We're not challenging the fact that the state education department conducts a review. We're not even challenging that it makes a determination. What we're challenging are the three consequences that flow from that determination, right? First, that parents, if the determination is non-equivalent, first, the parents must unenroll their children from that school. Second, instruction from that school can't be used to even partially satisfy the compulsory education obligation. And third, a child attending that school can't receive services.
So how would a parent in that situation, if the school is not qualifying as substantially equivalent, how would that parent meet the obligation, just practically speaking?
Well, so how would they meet it, Your Honor, or how would they communicate the fact that they've met it? That's-
No, how would they, in fact, meet it?
Either through homeschooling, or through tutoring, or through some extracurricular program. And in fact, the cases, and SED at this point doesn't seem to oppose it, the homeschooling cases, and if this court looks at In re Myers or In re Lash, those are two homeschooling cases where there are family court proceedings, and in both those cases, a homeschooling parent supplemented through a variety of activities. In re Lash, it was two separate tutors were also providing instruction to the child. In re Myers, in addition to the homeschooling, there was dance classes in one extracurricular academy, music in a second, and art in a third. And the courts are clear that supplementation works.
Counsel,
in that.
I know your light is on, but I have a follow-up to that, going to your third category, receiving services.
Yes, Your
How
Honor.
does that play in with the ability to supplement? Because would the state have the funding obligation to an entity that on its own doesn't provide a substantially equivalent education?
So I'm glad you raised that, Your Honor. I'd like to address it. The issue of what the state here is calling state aid is really a red herring. It's not in the regulations. It wasn't raised at trial court. It wasn't raised before the third department. And the reason is that what the state is referring to as state aid are really services to children, right? So if a child,
For example?
it could be bus transportation, but more likely it's physical therapy, occupational therapy,
But
speech
let's say
therapy.
bus transportation, let's stay
Sure.
with that one. So if the institution is not standalone providing a substantially equivalent education, why would the state have to fund busing?
Because the legislature says so. The legislature, right, 3635 says nothing, point one, which is where the transportation mandate is contained,
Right.
Says nothing about substantial equivalence. It says, a child is entitled to that transportation,
To go to a
to their
school that
school.
would meet the education law.
No, it says the school. It just says the school in 3635. And Your Honor, I think it's important to know that this.
That's the point, right? Whether or not it can be a school within that meaning, if it is not in furtherance
Well-
of the requirement imposed under the law.
Well, Your Honor, it's really a little circular, the state's position, but the state actually
So
takes a
what would
contrary
your
position.
definition of a school be?
Oh, so that's exactly what I was going to get to, Your Honor. The state has conceded now, and this concession is on page 5 of the last brief it's filed, and that was their short brief that they filed on April 25th. It responds to the amicus briefs. And on page 5 of that brief, the state concedes that homeschooling parents can combine sources. They can
And do they get busing?
Well, they don't get busing, but they get all these other services. The other services, home,
So
physical
what
therapy.
is the definition of school that entitles the busing when you're not a standalone significant?
So the State Education Department puts out a document called Home Instruction Questions and Answers. And it's available online, Your Honor. And question 6 on page 3 says, may groups of parents provide home instruction collectively by engaging the services of a tutor to provide group instruction to their children? And the answer is yes. And then it has a caveat. And it says as follows. Parents can do it, but for particular subjects, is a quote, for particular subjects, but not for the majority of the home instruction program, where groups of parents organized to provide group instruction by a tutor for a majority, but not the entirety, for a majority of the instructional program, they are, quote, operating a religious or independent school. So the court itself terms a group of students who are attending instruction by a tutor hired by their parents in the tutor's basement as a school.
And they get busing?
They're not asking for busing, Your Honor,
No,
but
but
they get
that's my
services at
question.
home. They
What
get
is the-
services. It's a school.
So what's the difference between that definition of school and a school that qualifies for busing?
Your Honor, I thought you were asking if they get busing at home. They don't get busing at home.
But let's say the students, they're all going to one home.
For majority, yeah, the state,
And why don't they get busing?
SED is calling it a school. 3635-1 says the trigger for busing is school.
So they
Your
do get
position
busing.
would be they get busing.
It would meet the statutory definition, Your Honor. They certainly get other services at home. Physical therapist, occupational therapist, speech therapist, special education services. The state has no problem requiring local school districts to provide those services to homeschoolers at their home, even
That's about
though
the
they are supplemented.
That's about the individual need of the student.
Sorry, Your Honor?
That's about the individual need of the student assessed as such.
That's exactly right, Your Honor. And in fact,
And busing to the tutor is not the same as, and you're saying you don't get paid for that, busing to an actual facility that has more than a tutor.
Your Honor, there's no doubt that these are schools, whether a school meets all the elements of substantial equivalence.
Maybe a school, it's whether or not it falls within and satisfies the requirements of the education law.
Your Honor, there's no statutory provision that they could turn to that either imposes, their definition or ties together busing with their definition. It just says school. And I want to say, Your Honor, it's if I can get to two other points. The first is, right, the state has taken for itself in these regulations the authority to require parents to unenroll
Okay,
from
well,
private
that's actually
school.
what I wanted to ask you about. Where is that in the regulations? Because I don't read them that way.
So it's in the regulation, Your Honor, because,
No, where? Where?
so it's in two places, Your Honor.
Yeah.
It's a combination of
identical,
two places.
right?
If one looks at Part 130.6, 622.
22, right?
Yes, Your Honor.
And 138D72, right?
Yeah, but, okay, yes.
Right? And what it says is, the LSA shall provide a reasonable time frame for parents or persons in parental relationship to enroll their children in a different appropriate educational setting consistent with Education Law 3204.
Right, which means they have to leave the
No,
school.
no, the command is to the LSA. It says the LSA has to give you time. It doesn't say you have to do it.
No, Your Honor, the LSA has to direct the parent to, absolutely, the LSA has to
That's not
direct
what
the
it
parent.
says.
Where does it say
has to
that?
direct the parent
Provide
to
a
do it.
reasonable
say
time frame.
It says they have to enroll, if one looks at, Your Honor, 130.6,
Yep.
C2,
Yep.
Roman 3.
Yep.
Parents, it says that they have to get a directive to, quote, enroll their children in a different appropriate educational
Where do
setting.
you see the word directive? It says a reasonable time frame.
To, quote, enroll their children
Yes,
in a different.
but it's not a directive to the parent that they must enroll. It's a directive to provide a time frame. Those seem
And
distinct.
to provide services in that time frame.
But, Your
which
Honor,
seems to me-
as I said, there's no question that the way SED interprets this and applies this and enforces it is to parents get letters. Once there's a determination of non-equivalence, SED sends letters to the school saying you must inform the parents that they have to find a new educational setting. And then the local school district follows up, and it says,
Are there any
quote,
of those
But counsel-
letters in the record?
excuse me?
Are there any of those letters in the record?
Your Honor, the question, let's go back to
I'm
first
just asking
principles.
if they're in the record or not, the letters.
The letters aren't in the record, but we're talking about the status of things. But let's go back, Your Honor, to what
Well,
Judge
counsel,
Reiber said.
counsel, hold on a second. If you don't want to answer that question, maybe you can answer this one. Again, this is DJ Article 78, right?
Yes.
So we have to make a declaration or annul a provision, and we just went through a lot of questioning that seems to suggest that some of the members of this court don't see any requirement that a parent disenroll their child. So what is there for us to annul?
Your Honor, the whole point about supplementation gets to this point, right? The state determines that this school is not a school that can satisfy any element of substantial equivalence.
No, what is any element of substantial equivalence?
That's what it says. It says that a school shall no longer be deemed a school which provides compulsory education fulfilling the requirements of Article 65.
Yeah, that would be all of the requirements, not any of the
It doesn't
requirements.
say. No, Your Honor, it doesn't say which provides fulfilling all of the requirements. It can't fulfill any of the requirements, and that's the point.
Wait, if I can. It could be read either way, it seems to me. It could be read to mean all, or it could be read to mean any.
And what Justice Reiber did below was say, you don't have to unenroll. That's exactly what she said. She said, you don't have to unenroll. You can, in fact, supplement.
So perhaps she's right.
Right, except, Your Honor, that the state appealed that, and the appellate division reversed it, and specifically.
It doesn't say unenrolled. Excuse me.
Yes.
It says you're notifying the parents that the resident students should be enrolled, right, in a different appropriate educational setting. That doesn't mean they have to be unenrolled. of where they currently are.
Your Honor, if
You're
you
the one who
can't
said they can supplement. If you could supplement, then you can be in both, can you not?
And that's what Justice Ribas said, and SED, instead of saying, that makes sense, they appealed. And the third department said, you cannot supplement. Explicitly said, you cannot supplement. It's too hard to go to a parochial school and do more, and therefore you cannot supplement. That was the basis of SED's appeal from Justice Ribas, and that was the clear, direct holding of the third department that's on appeal here today. But we agree, Your Honor, if this court would reinterpret 130.6,
Yeah, because that's a third department reacting to if you were going to have them enrolled in the school that's found deficient with respect to the education law for the exact same time period. But that may not be what the parent does.
it doesn't say for the exact same time period. The third department said,
But that was their point. There would not be any hours left in the week.
Your Honor, they said if you go to a parochial school that has school day ends at 5 o'clock, you can't supplement on weekends, you can't supplement on nights, even though the homeschooling regs say a homeschooling parent can use weekends and nights to provide instruction. And you know, parents, you know, beyond that, if you step back for a second, right, the parents, you know, have a constitutional right to choose their school, to direct the education of their children. The state can't deprive them of that right by virtue of a regulation, especially when the education law is quite clear about, you know, how it's enforced. This education law has numerous provisions that say if a parent is suspected of not fulfilling her compulsory education obligation by providing instruction that's, you know, elsewhere that's substantially equivalent, there's a family court proceeding. And in a family court, a judge looks at, you know, the totality of the circumstances and has a range of options in front of the court. And the court has, you know, broad authority. There are monetary fines and penalties. There's criminal sanctions, even jail time. And most importantly for these purposes, as in the case of David A., the court can, you know, issue an order of unenrollment. That's exactly, the legislature dealt with this long ago, and it said this is how it works. And it's important to note, Education Law 211F deals with the State Education Department Commissioner's authority to order unenrollment at public schools. And it greatly circumscribes that authority. There has to be a finding of very substandard performance for a large number of years in a row. After the school is performing deficiently for a number of years, they convene a committee, they talk about an improvement plan, they give them more resources, and it takes 10 years to do it. And we know that because of the Mulgrew decision, right? At one point, the State Education Commissioner got fed up and said, parents, you can't go to those public schools.
And who sued?
And lost. What?
Who sued?
The UFT. And they lost. The court said the Education Commissioner could not tell public school parents that they can't go to a public school that they found to be deficient. And here, Your Honor, you know, it's because of, so there's no support or authority in the education law, or certainly nothing that would give the State Education Commissioner, you know, greater rights here, especially, of course, when there are constitutional rights at play. As this court has said in Packard Collegiate, right, schools, non-public schools have a constitutional right to exist, and parents have a constitutional right to send children to those schools.
Thank you, counsel. You have your rebuttal.
Thank you, Your Honor.
May it please the court, Beasley Kiernan for respondents. I'll start with mootness. I actually agree with my opposing counsel that this case is not moot, and I think there are two separate justiciability questions here. First is whether the budget bill displaces the substantial equivalency regulations challenged here. We don't think they do. The second question is whether petitioners still have a personal stake in the outcome of this litigation. Because if all of petitioner schools, for example, choose this assessment pathway set forth in the budget bill, they may not be subject to a negative determination anytime soon. And that's really up to petitioners to demonstrate at this point.
Well, they're not subject to anything now, is that right?
That's right, and then that's why we...
So what about counsel's assertion that there are ongoing prosecutions?
There have been 6 schools determined to be not substantially equivalent because they intentionally refused to cooperate with local school districts in those reviews. If there are other schools,
And so as to those 6, does the statute affect them at all, or affect those determinations?
SED's position at this point is that the legislation does not affect those final determinations. And if I can just step back.
Wouldn't
and-
that then be the next case, not this case?
Absolutely, that can absolutely be the
So
next
again,
case.
why is this not moved?
Because, and I'd like to talk about what the legislation does. It takes the pathways that were already in the regulations. This is section 130.3 of the regulations. Those regulations allow non-public schools to demonstrate substantial equivalency if they were registered, accredited, if they conducted assessments. All those pathways were already in the regulations. The budget bill puts them in the statute and then elaborates on the accreditation and assessment pathways, creates a phase-in period for the assessments pathway. But a school doesn't have to choose one of those pathways. And the bill even makes clear that it doesn't preclude the commissioner from defining alternative criteria for substantial equivalency by rule or regulation. That's the final subparagraph in the budget bill.
An alternative would mean additional or to replace the statutory pathways?
Additional ways to demonstrate substantial equivalency.
So you keep the one that you've been previously prosecuting under, but there are other alternatives available to the school. I take that to be your argument.
That's right. There have always been these alternative pathways, but if a school didn't choose one of those pathways, then it was subject to
Can
the
I
review
just ask you
process.
regarding enforcement, and I know you have a lot more you want to say about the scheme, the regulatory scheme, but does the current reg give SED the authority, once a lack of substantial equivalence is found, to direct or compel disenrollment of students from schools?
No, the regulations don't purport to authorize that kind of order. As Your Honors noted, the relevant provision requires the commissioner and local school authorities to give parents a reasonable time frame to affirmatively enroll their children in a different appropriate educational
It
setting.
seems to me to be tied to funding. You have to continue funding for a reasonable time to the school while the parents find some other arrangement, potentially, right?
That's exactly the purpose, yes.
What is the authority of the state to stop funding once substantial equivalency determination is made? Lack of.
Because the legislature has conditioned state aid, state services on a non-public school satisfying substantial equivalency.
Where is that?
So for example, mandated services aid, it's a session law. It's also at 1131 of the record. It states that non-public schools that provide instruction in accordance with Education Law 3204 shall receive this mandated services aid. 3204 is what sets
But there are
forth.
also services that are available to children on an individual basis. Let's say a particular child is dyslexic, the state and local district has an obligation to provide services, no?
That's a separate kind of service. Mandated services aid are, it's a limited category of money for services that schools have to provide in compliance
So other
with.
than busing, what would that be?
So besides busing, so there's one statute, 3602-C, which does talk about disability services and gifted and talented programs.
What other services would be suspended with a non-compliant private school, other than busing?
The state aid and the gifted and talented programs, career and occupational services, under 3602C, those services are made available to students attending non-public schools. And the statute even makes clear that
But only compliant non-public, substantially equivalent non-public schools. In other words, you have the authority to discontinue those funding streams if there's a finding of non-compliance.
well, the statute just says non-public schools.
And so are that category of services, are those provided to parents who are homeschooling their children?
No, and 3602C actually distinguishes between parents enrolling their children in a home instruction program versus non-public schools. It says that solely for purposes of disability services, children receiving instruction in a home instruction plan shall be deemed students enrolled in a non-public school for purpose of the other provision saying that non-public school
And
students.
counsel, what about
receive
supplementation? We had some argument regarding what Justice Reba held and what the appellate division held. Where does SED stand on the ability of parents who want to continue to have their children attend even a non-compliant private school to supplement their education?
So just to be clear, parents can provide instruction for their children from whatever source they choose, but they do have the responsibility to ensure that their children receive the compulsory education they're entitled to. So the education law offers 3 avenues for parents to fulfill their obligations. Of course, you can enroll your child in public school, you can enroll your child in a substantially equivalent non-public school, or you can enroll your child in a substantially equivalent home instruction program. And the education law authorizes dual enrollment in a few discrete areas we've already discussed, 3602C, gifted and talented programs, disability services. But otherwise, the education law doesn't contemplate the kind of hybrid education.
So there is no enrolling your student in a non-substantially equivalent private school and then supplementing that training with tutoring and programs outside the school. That's, your position is that's not allowed.
There's no precedent for that, and we're using enrollment as a
Why
term
isn't
of
the
art.
reverse allowed? You enroll them in a school that's compliant, we'll just use that phrase for the moment, and you keep them enrolled in the school that the department or the commissioner or LSA have determined is not substantially equivalent, because together it's enough.
There's no precedent for that kind of model.
Are there enough hours in the day to do that? Isn't one of the requirements that you be open for a certain number of hours in instructing?
You do have to be instructed a certain amount of time per day, although the school districts do have a little bit of flexibility there.
On the dual enrollment, one of the amici make the argument that allowing dual enrollment only in some circumstances, but not here, runs into the restrictions the Supreme Court has explained are in place on treating religious activity less favorably than comparable secular activity. So why does this not run afoul of that constraint? The restriction on dual enrollment that you articulated.
The regulations, the statute, treat all types of schools equally.
But I thought you just said, correct me if I'm wrong, the dual enrollment, and I think this is confirmed, is permissible in other circumstances, but I thought you said not here.
There is statutory authority in a few discrete areas for what the statute's called dual enrollment.
Right. And
But
so-
even those statutes, take as a given that you're enrolled in a substantially equivalent non-public school or a substantially equivalent
So those
home instruction
exceptions,
program.
that's like working children and stuff like that? Are those the exceptions you're talking about?
No, Your Honor. And the statutes call this dual enrollment. It's not really dual enrollment. You still have to be enrolled in one school, and then you can receive services from another school.
Could the parents keep their children in a non-public school that was designated not substantially equivalent and supplement as appropriate through the homeschooling route?
What they absolutely can do is craft a home instruction program, and as part of that home instruction plan, they can certainly rely on classes at a former non-public school, absolutely.
That
What is
school
your-
just would not receive services.
Yes,
right?
that school wouldn't receive services.
What's
Your time is going to start running out. Can I just get back to the mootness? Because I'm unclear as to, given what you said at the beginning, when you started out with mootness, what decision we could render that somehow would provide a remedy that survives this new legislation.
So as I mentioned, schools don't have to choose this safe harbor, as
Yeah.
the legislation calls it. Schools can say, we don't even want to do assessments, or for whatever reason, we just want to we would rather be subject to the reviews by the commissioner. So those schools would
But do we
certainly-
know that's the case
Yeah, what-
now?
what-
I mean,
what is- what
that
is these-
question hasn't been presented to them yet, I don't think.
That's what's difficult, Your Honor. We don't know if any of petitioners, members of petitioners' organizations, we don't know what they'll do. in
But that's the
response.
point. Why isn't it moot then? Because we don't know as I said to you before, that's the next case.
Or not ripe.
They have more options now than they did before last week.
They do, and that goes to the separate, the second justiciability question I mentioned. We take the position that the regulations are still in effect, and in that sense, the case is not moot. But to the extent petitioners...
Well, okay, then there can be a lawsuit about that,
Sure.
given the new legislation. All right, what's the second point about?
To the extent
Yeah.
any of petitioners' schools, member schools, are no longer affected by the regulations, then they wouldn't have a personal stake.
So are any of the 6 schools you mentioned that you have been deemed, are there any of those the plaintiffs here?
I don't know, Your Honor. Petitioners have never quite made clear which schools are members of their organizations, and I don't know whether those 6 are.
And why is it your view that the schools for which there has been some determination made are not affected by the statute at all, including the, whatever it is, 2 or 3 year window?
This is, and State Ed is still digesting this budget bill, which just passed, but I think State Ed's view is they made a final determination that this is no longer a non-public school. It's still receiving services during the reasonable time frame, but these determinations were made.
Is there any room under the statute, either previously or as amended, to allow a school to remediate in some way after a determination is made?
Not that I can, not that I know.
So the window in which there's some consultation back and forth that's contemplated by the prior iteration of the statute, SED would not respond if a school came forward and said, you know, we would like to try this again.
Your Honor, I don't want to, I'm not sure what would happen. At least for these 6 schools, they did have a remedial period. They had a lengthy period.
I understand.
to
I
approve.
mean,
Right.
if there was a
But they may
further
very
effort.
well argue this now, the statute puts them in a different place, and again, that's another lawsuit.
That's a different case. That's,
Could I
that's
just
right,
ask
Your
you, why are those schools, those 6, still receiving aid? Is that as a result of some injunction, or is that just by the grace of SED?
No, it's this reasonable time frame language.
Oh, so the time to end the aid has not yet expired?
Right, we are still in that time frame.
So the reasonable time frame is, I've forgotten, it's 90 days?
It's whatever, I think it's whatever's reasonable under the circumstances. I'm not sure if there's a specific. So in this case, these determinations were made in February, March of 2025. Services will continue through this school year, which is about to finish at the end of June, I believe.
So I'm sorry, these determinations were made post the litigation?
Yes, yes, very recently, obviously well outside the record. But for purposes of mootness, you know, these schools would be affected, I think, by a decision in this case. It's just unclear to us whether they're actually members of
And those
petitioners.
determinations aren't in the record here.
Right, they're not in the record here.
But that.
And the
But
identity,
that might all be for naught, depending on the new legislation, which has not gone through any process yet, right?
Yeah, Your Honor,
Litigation
there are
process, you
unknowns.
haven't reviewed your regulations to see if you need to amend them, correct?
Right, and 130.3 of the regulations that sets forth the pathways, that'll need to be amended for sure.
That will need to,
That will need to be amended in light of the budget bill. The other regulations, I think, still stand.
which section are you conceding needs to be amended? 130 what?
130.3.
130.3.
Thank you.
just so I'm clear, the record doesn't include any documentation, I take it because it's recent, you're saying, of the final actions, nor does it reveal the identity of the particular schools, is that right?
That's right. I'm not aware of any indication in the record of
Thank you.
those schools.
Thank you.
Thank you. Could I just briefly?
Yes, if you need a minute,
on-
sure.
Yes, on vacatur, vacatur would not be necessary here. This court's general practice is simply to dismiss an appeal that is.
Although in some circumstances, we have vacated, for example, Hearst suggests that where there's an immediate consequence, that might be appropriate.
Yes, in a few cases, the court has done so. In Hearst, there was an intervening Court of Appeals decision that post-dated the appellate division's decision. So I think for that reason, the court
Is your view
vacated it.
that if it was determined to be moot and not vacated, that the aspects of the regulation currently under review that might not be changed could no longer be challenged?
They could certainly be challenged.
By other parties, I assume?
Yes, I mean, this was a declaratory judgment action. You could always bring those claims up again, and especially in an as-applied claim. This was a facial case. The court just upheld the regulations on their face.
But again, you have new legislation, and things may change.
That's right, Your Honor. So if Your Honors do find that this case is moot, we urge you to just dismiss the appeal and not vacate the Third Department's well-reasoned opinion. Thank you very much.
Thank you, Your Honor. A few points. With respect to mootness, what we just heard from SED is that they concede that they're continuing with respect to the 6 schools. I don't believe they gave an answer with respect to the 18 schools.
Do we know does the record show what those 6 schools are?
In terms of the names?
Yeah.
The record, no, because the determinations post-date the filing of the lawsuit.
And
But,
does the record show us who your member schools are?
yeah, so I think the record shows, Your Honor, there are 8 plaintiffs or petitioners altogether, 3 institutional petitioners. The first is Pearls, in short. The second is Agudath Israel, and the third is the National Society for Hebrew Day Schools. And I think the record demonstrates that essentially all of the Jewish schools in New York are members of one or more of the institutional petitioners. So they're definitely covered, and in fact, they are among the 6 schools members of Pearls, and among the 18 schools there are members of Pearls. So absolutely, and as I say, both of those go on, and it's unclear why there would be any difference in how SED treats one or the other. So they conceded about the 6 schools that they're continuing. They didn't answer about the 18 schools, but the facts show that they are continuing. And generally, mootness means a threatened injury has been removed. And here, SED says they retain the authority on the challenged part of the regs, and they're going to vigorously defend them. So I think the threat, in any event, hasn't been removed. With respect to combination of sources, so for the first time, the state has conceded that a parent, can combine sources, including a private school parent. A parent can supplement. Now, that's contrary to the 3rd Department, so I think the court would still have to enter something that made clear that that right exists for parents. Otherwise, we just have Mr. Kiernan's word for it today. And Your Honor, I just want to point out...
Counsel, why do you say it's contrary to the 3rd Department? I see language in the 3rd Department decision from the majority saying, contrary to your assertion, loss of status is not equivalent to closure. The institutions may, in fact, continue to operate and provide some form of instruction, and it does not limit the parents' opportunity to enroll their children in any extracurricular instruction or activities that they deem appropriate and helpful. That seems, I don't see that as a prohibition. I see that as an endorsement.
You're on a couple of things. First of all, extracurricular instruction is not a school, right? The school has a particular meaning. In fact, the statute, the Not-for-Profit Law 414, distinguishes between schools and other institutions for educational purposes. And these are indisputably schools. And we're talking about the legislature, set up this process. Again, we're talking about rights that the parents have and that the schools have. And, Mr. Kiernan is not, rooting the arguments about SED's authority in any act of the legislature. And that is deeply problematic here. That's in fact what's wrong with exercising this power. Again, what we know that the legislator has says is that the power, he says, his commissioner has over private schools, she doesn't have over public schools. And that simply, Your Honor, can't stand. So the case is not moot. I guess I would say as a final point, Your Honor, that so if they can combine sources, that's fine. We just need a determination that says that. The issue of state aid, if one looks, Mr. Kernan talked about the local law for mandated services. It doesn't say substantial equivalence. It talks about, it does reference 3204, which has numerous provisions in it, including the number of days they have to offer school and the number of hours during the year there has to be schooling. So there's nothing in that local law in Chapter 507, as Mr. Kernan referenced, that has any reference to substantial equivalence. And so we don't think so. And with respect to services, Your Honor, the home services, the services that children who are homeschooled receive, go, far beyond, attending gifted classes or remedial classes. They are services that are individual to the child at the place they receive instruction. That's just the reality, and the state has ignored that, but that's what they're saying. The state still persists in saying that a child who stays in the parochial school the parent chose for them and supplements at home can't get services at the school. And it's important to know that if one looks at the amicus brief that the parents filed.
And can't get services at the home either?
What?
And can't get services at the home?
But it makes more sense to get it in the school setting, Your Honor.
That's not what I'm asking, right? So let's take counsel at his word that, and I think the appellate division of their word, that you can keep children enrolled in the school even if it's not designated as a school, and you can supplement that with homeschooling and meet the substantial equivalent requirement that way. Take that hypothetical, all right? Is there a reason that you think you couldn't get the services at the home?
Well, Your Honor, take the school that is the one attended by the parents who submitted an amicus brief, right? The state concedes, the state gave that school a review, and they said your English language arts instruction from K through 8 is good. It's fine. We like it. They said your math instruction from K through 8 is good. We like it. They said your science instruction, we love your STEM classes for the older science grades. We had a problem with 3rd grade science, and we had a problem with, I think it's 5th grade history. And as a result, they just said blanket, the school's not equivalent. And why, in God's name, would the state have any legitimate policy interest in saying the child can't get services at that school? Child spends the day there because the parents choose it for its religious mission, its religious values. Its instruction in math and lots of science and history is good. It's just punitive. It's because the state is trying to obtain over private schools authority that the legislature has not given it. It's just a punitive mechanism, Your Honor. The state has an interest in what the kids learn, not where they learn it, and once we acknowledge that there could be a combination of sources, there's absolutely no legitimate reason to start penalizing schools, whether it's through using monetary means or through penalizing the parents who choose them by saying where your child spends the day with his teachers, with her friends, where she learns almost everything, can't be where she receives resources. Is the state really going to start sending these people to homes on the evenings and on weekends? They're not going to, Your Honor. And more importantly, they don't have the right to withdraw them from the student if the student has chosen that school, if the parent has chosen that school. Final point, Your Honor, is if this court thinks that somehow there needs to be a greater expansion of the record, we think the appropriate method of doing that would be to remand it to Justice Ryba, who had the case first, and that can be done before Justice Ryba. But it wouldn't be appropriate to moot the case. It wouldn't be appropriate to dismiss the case. It wouldn't be appropriate at this point to start entertaining arguments about justiciability. If we think there's enough there, the state argues it's not moot. The way the statute works, right, is not similar at all to any of the mootness cases of this court. In those cases, indisputably, the threatened harm has been removed, or the issue complained about or being adjudicated was removed, whether it was in Hearst with the transcript, or whether it was in Victoria P. because the protective order had expired, or whether it was in Rubenstein because his suspension had expired. In all those cases, indisputably, one's not parsing statutes or asking questions, what's going to happen in the future? Indisputably, the harm was removed. And even then, in most of the cases I mentioned, the court said it's not moot because consequences could flow. That's all this court requires in its cases to see if there's a possibility of legitimate consequences that could occur in the future. And there's no doubt that there's 24 schools.
What consequences are going to flow? Let's say we agree with the state. You have now a statute that gives you another pathway.
I'm sorry, I couldn't hear.
Let's say that we agreed with the state. We ruled in their favor. Don't you have now a piece of legislation that allows you, nevertheless, to continue to provide educational services and programming to the children?
Your Honor, the six schools, for their own ideological, constitutional reasons, right, didn't choose assessment beforehand. There's no reason to think that the schools that refused to choose assessment, which got them to the point they're in now, are going to change just because the state somewhat broadened the assessment pathway. This is a...
It's very hard to make the argument that the education law doesn't allow them to assess. You may disagree in the way they enforce their conclusions based on the assessment.
Let me correct the misnomer, Your Honor. I apologize. When I say assessment is a pathway by which the school administers a state assessment test and uses that performance in one way or another. So I'm sorry. And there are schools that had their own ideological constitutional reasons why they say the state can't require us to take their test to demonstrate it. And what everyone thinks about, that view.
Okay, so if that's these six, and that has been determined after the commencement of the litigation, they have their options.
Your Honor, they had those options before. Assessment exists in the regulations. What Mr. Keenan referred to as 130.3 had the same list of pathways that a school could use to avoid a local school authority review. What this legislation does, it takes two of those, the accreditation pathway and the assessment pathway, and it broadens them to some degree. It didn't create any new pathway to avoid a review that came earlier. So again,
But it does seem the legislation was heralded by the non-public school community as a significant win. It seems to me you're arguing now that you gained little.
Your Honor, that same community, I think, felt very strongly and heralded the problems with the regulations because it gave SED
No, but
authority it doesn't have.
I'm asking you about the legislation.
You're asking
The
about,
comment is about the legislation.
right? And the question is whether there were press accounts?
Well, it seemed to me that you were now arguing that it gives very little. That
I'm not
it
saying it's
changed
little.
almost nothing.
I'm saying, Your Honor, it does not remove the threat. If this court finds that the regulations, that the new legislation occupies the field.
I'm saying it's,
and it-
it
and it-
perhaps,
and it-
my point in this way, in response to you, is perhaps it has changed the nature of the threat, and that requires future litigation, if anything.
Your Honor, the court, I don't think for mootness analysis speculates like that. Again, in Victoria P., the issue was the order of protection had expired. However, this court was concerned that the individual who was previously the subject of a long ago expired, by then long expired order of protection might in the future commit a crime. And he would be caught committing that crime and be prosecuted. And the judge who is overseeing that it would learn of the order of protection, and he would be convicted. And in the process of sentencing for that conviction, for that crime, by the order of protection would take it into account in some way down the line. The order of protection would be taken into account as some factor in sentencing. And based on that potential, the guy has to commit a crime, be arrested, be convicted, and the judge has to have this order of protection against him. The judge said that makes it not moot. That makes it have legitimate, plausible value from an appellate decision. This case is a lot easier than that one, but again, if this court has any questions about the record or something, the proper approach would be to remand to Judge Riba. Thank you.
Thank you.